Hey, everyone, Billy here. The most powerful courtroom in America just held its breath for 6 minutes. It happened at exactly 2:47 p.m. Eastern Time in a federal courthouse in Florida, where a simple centuries-old protocol, standing when the judge enters, collided with the defiant will of a former president of the United States. Donald J. Trump, facing criminal charges over the alleged mishandling of the nation's most sensitive secrets, remained seated as Judge Aileen Cannon took the bench. What followed was not a legal argument, but a raw test of power. Federal marshals stepped forward, their movement a silent, physical punctuation in the tense air, hands hovering near their equipment as a standoff unfolded in real time. This was not a debate over evidence or a procedural objection. This was a fundamental rejection of judicial authority itself, played out before a stunned courtroom and forcing the guardians of federal order to prepare for an unthinkable scenario, physically compelling a former commander-in-chief to show respect for the law. To understand the magnitude of this rupture, you must first understand the setting. This was a pre-trial hearing in the classified documents case, already one of the most consequential in American history. The air was thick with the gravity of national security. Hours before, newly unsealed FBI memos had painted a damning picture, not of accidental retention, but of deliberate concealment. The evidence allegedly showed Trump personally ordering the movement of boxes containing top-secret materials, details on nuclear capabilities, foreign intelligence assets, military plans, around his Mar-a-Lago residence for 18 months after leaving office, despite repeated federal demands for their return. This was the backdrop. Not a paperwork dispute, but an allegation of willful obstruction at the highest level. Judge Cannon had just returned from a recess spent reviewing this incendiary evidence. As she re-entered the courtroom, the bailiff's traditional call, "All rise," echoed off the wood-paneled walls. Dozens of people, prosecutors, defense attorneys, journalists, court staff, stood in unison, every person except one. Donald Trump remained in his chair at the defense table, his attention apparently absorbed by his phone. A silence descended, so profound that observers reported hearing the hum of the ventilation system. Judge Cannon's eyes found him. "Mr. Trump," she said, her voice cutting cleanly through the quiet, "please stand for the court." He looked up, made brief eye contact, and returned to his screen. The silence stretched, becoming its own presence in the room. 15 seconds later, Judge Cannon spoke again, her tone now stripped of any superfluous courtesy. "Mr. Trump, I am directing you to stand for this court. Now." This time, Trump looked up slowly, a deliberate theatrical pause. Then he delivered the line that would transform a protocol breach into a constitutional incident. "I don't recognize the authority of this kangaroo court," he stated, his voice carrying clearly to the press gallery, "and I'm not standing for it." In that moment, the theoretical rule of law became a physical reality. Two federal marshals, stationed near the doors, took synchronized steps forward. The sound of their shoes on the floor was startling in the quiet. They did not draw weapons, but their posture shifted, their hands moved to their sides, ready. They were following a protocol drilled into them for situations where a defendant disrupts court order, but their training manuals contained no chapter on a defendant who was also a former president, surrounded by a Secret Service detail. The standoff was now live. The judge's command, the defendant's refusal, and the armed enforcers of judicial authority caught between them. For 6 agonizing minutes, the courtroom froze in this tableau. Trump's own lawyers were visibly panicked, leaning in to whisper urgent pleas. The prosecutors watched, stone-faced. The marshals held their position, a human buffer between the bench and the defiant man. The entire edifice of American justice seemed to balance on a knife's edge. This act of defiance is historically unique. Past presidents have clashed with the judiciary, but never from the defendant's table, and never over a ritual as basic as showing respect for the bench. Richard Nixon, facing the Supreme Court's order to surrender the Watergate tapes, complied. Grudgingly, but he complied. Bill Clinton, ordered by the Supreme Court to sit for a civil deposition, showed up and answered questions. They operated within the system, even as they fought it. Trump's refusal was different in kind. It was not an appeal to a higher court. It was a denial of the current court's very legitimacy. As Harvard's Lawrence Tribe later put it, this was a categorical break from 235 years of tradition. It wasn't a legal challenge. It was an anti-legal performance. The reasons for his defiance are buried in the evidence that prompted the hearing. The unsealed FBI memos didn't just suggest sloppiness, they alleged a pattern. Audio recordings, described by sources, reportedly captured Trump telling aides to keep certain documents because they prove I was right. This is the mindset of someone who believes his personal narrative trumps classified protocols. That same mindset, legal scholars argue, fuels the belief that a courtroom's rules are optional if he deems the process unfair. He wasn't just breaking a rule, he was acting out a worldview where his own judgment supersedes established institutions. The Marshals' advance created an impossible dilemma for every branch of government in that room. For the Marshal Service, their duty was clear: maintain court order. Yet, physically touching a former president was a political and security quagmire without precedent. For the Secret Service, their duty was to protect the former president, even in court. Would that protection extend to shielding him from marshals enforcing a judge's lawful order? For Judge Cannon, her authority had been publicly spat upon. The tools at her disposal, contempt of court, immediate detention, were designed for ordinary defendants. Using them on a former president risked inciting a political firestorm. Not using them meant her court's authority was now conditional on the defendant's approval. The immediate aftermath was a storm of conflicting realities. On Truth Social, Trump raged, calling Judge Cannon nasty and biased, and framing the Marshals as Biden's personal enforcement army. This narrative played perfectly to his base, who saw the event as righteous defiance against a corrupt system. But in the world of law and precedent, his actions were potentially self-incriminating and certainly destructive to his own legal position. Defense attorneys nationwide took note. If Trump doesn't have to stand, why should their clients? Prosecutors worried about the Trump precedent, creating a two-tiered system where courtroom decorum is negotiable based on fame. As former federal prosecutor Glenn Kirshner stated, the fact that we're debating whether to enforce basic rules shows how far the system has been compromised. We are now left with the fallout, which is both procedural and profound. Judge Cannon must rule on whether to hold Trump in contempt, a move that could range from a fine to brief detention. Prosecutors may seek to revoke or modify his pretrial release conditions, arguing his conduct shows disrespect for the court's authority. But beyond the legal mechanics lies the deeper damage. The 6-minute standoff was a live demonstration of a central tension in our current era. Is the law a set of neutral rules, or is it merely an obstacle for the powerful to navigate or ignore? The courtroom, in that moment, became a microcosm of America. On one side, the robe, the gavel, the Marshals, symbols of a system built on process and equal application. On the other, a man who embodies a philosophy of personal sovereignty and transactional power. The Marshals' approach was the system's instinctive response to a direct threat. Their pause was the system's confusion when the threat came in a historically unimaginable form. The coming days will reveal whether our institutions can withstand this stress test. Can a judge enforce her own authority when the defendant commands a movement? Can the principle that no one is above the law survive a direct, televised challenge from someone who was once the law's chief executive? The 6-minute standoff is over, but the question it posed hangs in the air, heavier than any gavel. When a former president sits down, who or what will make him stand?